Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host Aaron. Today, we're covering one of the most important concepts in immigration delay litigation, the TRAC factors.
This is a topic that comes up in virtually every Mandamus or APA delay case. If you're considering federal court action to resolve an immigration delay, you need to understand how courts evaluate whether a delay is unreasonable.
So let's start with the basics. What are the TRAC factors?
The TRAC factors are a set of 6 considerations that federal courts use to determine whether an agency's delay in acting on a matter is unreasonable under the Administrative Procedure Act. The name comes from a 1984 case called Telecommunications Research and Action Center v. FCC, TRAC for short.
And even though that case had nothing to do with immigration, courts now apply these factors to immigration delay cases.
Exactly. The D.C. Circuit developed these factors as a framework for evaluating any claim that a federal agency has unreasonably delayed action. Over time, district courts across the country adopted this framework for immigration cases, and it has become the standard analysis.
Let's go through each factor. What is the first TRAC factor?
The first factor asks whether the agency's timing follows a rule of reason. In other words, is the agency following a rational and consistent approach to processing cases, or is it acting arbitrarily?
How do courts apply this in immigration cases?
Courts look at whether U.S.C. or the relevant agency has a coherent system for handling applications. If cases are being processed in roughly the order received, or if there's a logical explanation for the processing sequence, that tends to favor the government. But if a particular applicant's case has been sitting untouched while similar cases move forward, that raises questions.
So it's not just about how long you've been waiting. It's about whether the agency is acting rationally.
Right. An applicant who has been waiting 2 years while similar cases filed after theirs have already been decided may have a stronger argument than someone who has been waiting 3 years but whose case is progressing through a normal queue.
What is the second factor?
The second factor examines the extent to which Congress has provided a timetable for agency action. If Congress has indicated that certain decisions should be made within a specific time frame, courts give that significant weight.
Are there examples of congressional timelines in immigration law?
Yes, the most well-known is Section 1447B for naturalization cases. Congress provided that if U.S.C. does not make a decision on a naturalization application within 120 days after the examination, the applicant can seek judicial review. Another example is the I-829 petition for EB-5 investors, where the statute contemplates a 90-day adjudication period.
Is that 90-day period as clear-cut as the 120-day rule for naturalization?
Not quite. The I-829 90-day language is tied to the interview stage, and it becomes disputed or effectively absent when USCIS waives the interview, which happens in many cases. So courts tend to treat it as a contextual benchmark, indicating congressional intent for prompt adjudication, rather than a fixed statutory deadline that automatically triggers jurisdiction.
What about cases where Congress hasn't specified a timeline?
That's most immigration applications. Congress has not set specific deadlines for I-485 adjustment of status, asylum applications, or most visa petitions. In those cases, this factor is neutral. It neither helps nor hurts the applicant's argument.
What is the third factor?
The third factor considers the effect of delay on human health and welfare. Courts recognize that some delays cause more harm than others, and delays affecting health, safety, or basic human needs deserve priority.
How does this apply to immigration applicants?
Immigration delays often have profound effects on people's lives. An applicant waiting for a green card may be separated from family members abroad. Someone waiting for work authorization may be unable to support themselves or their family. A person in removal proceedings may face detention. An asylum seeker may be unable to safely remain in their home country.
So applicants should document the specific harms they're experiencing.
Absolutely. This factor is one where the applicant's individual circumstances really matter. Courts want to know the concrete impact of the delay, not in abstract terms, but in terms of what is actually happening to this person and their family because of the agency's inaction.
What about the fourth factor?
The fourth factor considers the effect of expediting one applicant's case on agency activities of a higher or competing priority. Courts recognize that agencies have limited resources and must balance many responsibilities.
This sounds like it could favor the government.
It often does, at least in part. USCIS regularly argues that it has a large caseload, limited staff, and competing priorities. Courts generally accept that agencies must allocate resources and cannot process every case immediately.
But there are limits to that argument.
There are. Courts have noted that resource constraints cannot excuse indefinite delay. An agency cannot simply point to a heavy workload as a permanent justification for failing to act. At some point, the delay becomes unreasonable, regardless of competing demands.
What is the fifth factor?
The fifth factor looks at the nature and extent of the interests prejudiced by the delay. This overlaps somewhat with the third factor, but it focuses specifically on the legal and practical interests at stake.
Can you give some examples?
Sure. An applicant for adjustment of status has an interest in obtaining permanent resident status, the ability to live and work permanently in the United States, to travel freely, to petition for family members. An asylum applicant has an interest in protection from persecution. A naturalization applicant has an interest in becoming a citizen with full political rights.
These are significant interests.
They are. Courts have recognized that immigration status affects nearly every aspect of a person's life. The longer these applications remain pending, the longer applicants are denied the benefits Congress intended them to receive upon approval.
What is the sixth and final factor?
The sixth factor asks whether the agency has acted in bad faith. This is a difficult factor for applicants because courts generally presume that agencies are acting in good faith, and proving otherwise requires specific evidence.
What would constitute bad faith?
Evidence that the agency deliberately delayed a case for improper reasons, targeted an applicant based on impermissible criteria, or intentionally ignored a case despite knowing it required action. These situations are rare, and most applicants cannot point to evidence of bad faith.
So this factor usually doesn't help applicants.
Correct. In most cases, the sixth factor is either neutral or favors the government. But when there is evidence of bad faith, for example, evidence that an applicant's case was flagged for enhanced vetting based on national origin or religion, it can be very significant.
Once a court has considered all six factors, how does it reach a conclusion?
Courts balance the factors based on the specific circumstances of each case. No single factor is dispositive. A case might be strong on some factors and weak on others, and the court must weigh them together.
Is there a formula or threshold?
No. Courts have consistently declined to establish bright-line rules. They will not say that any delay over a certain number of months or years is automatically unreasonable. The analysis is inherently fact-specific.
That makes it harder to predict outcomes.
It does, but it also means that applicants with strong equities, significant harm, long delays, evidence that their case has been treated differently from others, can make compelling arguments even without a statutory deadline in their favor.
How do immigration attorneys use the TRAC factors when building a case?
A well-drafted complaint will address each factor and explain why the balance favors the applicant. The attorney will gather evidence showing the length of delay, the harm to the applicant, any evidence of inconsistent processing, and the nature of the interests at stake.
What kind of evidence supports these arguments?
Processing time data from U.S.CIS showing how long similar cases typically take. Documentation of the specific harms the applicant has suffered, financial losses, family separation, employment problems, health impacts. Any correspondence with the agency showing that inquiries have gone unanswered. Evidence of the applicant's eligibility and the completeness of their application.
So the TRAC factors provide the legal framework, but the facts of the individual case determine the outcome.
Exactly. Every case is different, and courts apply the TRAC factors to the specific facts before them.
Let's summarize the key points from this episode.
First, the TRAC factors are a 6-part test that federal courts use to evaluate whether an agency delay is unreasonable under the Administrative Procedure Act. The factors consider the rule of reason, congressional timelines, effects on health and welfare, competing agency priorities, prejudiced interests, and agency bad faith.
Second, no single factor controls the analysis. Courts balance all 6 factors based on the specific circumstances of each case. Cases with strong equities on multiple factors, particularly significant harm and evidence of inconsistent processing, tend to be more successful.
Third, applicants should document the specific impacts of delay on their lives and gather evidence showing how their case compares to normal processing times. The TRAC factors provide the legal framework, but concrete facts about the individual case determine the outcome.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.